Thank you much, Mr. Speaker. Today I rise to speak on C-77, a very important, though tardy and still an incomplete piece of legislation. The last time that there were major reforms in our military justice system was 1998, in what was then Bill C-25. And at that time, Bill C-25 specified there would be a 5-year review of those extensive reforms that had been mandated in law. That review was completed by the very distinguished former Chief Justice of the Supreme Court of Canada, Antonio Lemaire, in September of 2003, 15 years ago. The conclusions reached by Justice Lemaire was that after 5 years of experience with the reformed justice system, it was generally, quote, working well, but he went on to say that it was, and I'll quote him again, not entirely without room for improvement. And now that's a very moderate statement, as Justice Lemaire is wont to make. He then submitted 88 recommendations for those improvements. Justice Lemaire made recommendations in 3 main areas: actions to increase the protection of the independence of military judges, actions to improve the grievance process within the Canadian military, and actions to address some major deficiencies in the overall military justice framework. Now, here we are, 15 years later, and we are still dealing with important issues in this bill, a bill that was delayed 3 times by intervening elections, I will say. But let me say, both the Liberal and Conservative governments, as we heard them tossing at each other earlier in this debate, have been slow to act on these important changes. On the first recommendation of the independence of military justice, the Conservatives did act early in the last Parliament in a separate bill, which was then Bill C-16. This was dealt with on an urgent basis because a deadline had been set for changes regarding the independence of judges by the Court Martial Appeal Court decision in the case of R versus LeBlanc. This deadline was met with royal assent on November 29, 2001. So for me, there's the proof that we could have dealt with all of these things very expeditiously. There was a will in Parliament, the Conservatives had a majority. We could have gotten through all of these reforms 7 years ago. However, all the other recommendations had to wait. When the Conservatives finally did introduce what was in the last Parliament, Bill C-15, in October of 2011, it contained many, but not all, of the needed reforms. But even then, progress on the bill was slow. It took 2 years to pass through the previous Parliament, and it only received second reading a year after it was introduced. So the bill sat for an entire year without any motion, debate, or effective action on it. And finally, in May of 2013, the bill passed this House, and for once the Senate did act expeditiously, and the bill received royal assent in 2013. But here's the kicker on this one. Most of the reforms mandated in the bill did not come into force until September 1st this year. So even though the bill passed 5 years ago, it's only last month that its provisions came into effect. Again, 15 years after those reforms were recommended by Justice Lemaire. Why is that the case? I think it's pretty simple, and that is that our military justice system remains woefully under-resourced, no matter whether Liberals or Conservatives have been the government. Lemaire's recommendations specifically recognized 4 important principles to guide reform of the military justice system. His first was, and I'll quote him here, maintaining discipline by the chain of command is essential to a competent and reliable military organization, end quote. None of us in this House would disagree with that recommendation. It is important to keep in mind because, as my honourable friend from Selkirk, Interlake Eastman pointed out, there are times when the military justice system has to be faster and has to be perhaps harsher than the civilian system. His second principle was that it was necessary to recognize the particular context of a military justice system. Meaning, and let me quote him again, we need to have a system that will properly operate under those special conditions that our men and women are placed in, often abroad, under conditions from peacekeeping to war fighting, in what is often a hostile environment, and indeed, sometimes outright war. End quotation. His third principle, and I think it's perhaps one that's most important to me, is that those who risk their lives for our country deserve a military justice system that protects their rights in accordance with our charter, just like all other Canadians. And his fourth principle said that it's necessary to recognize, and I think this is also an important point, that any doubts or lack of confidence in the military justice system may have negative impacts on morale as a result of concerns about injustice. So the system has to be fair and seen to be fair so that it serves the interests of those who are risking their lives to serve this country. So returning specifically to Bill C-77, New Democrats are supporting this bill at second reading, and we have recommended expediting this passage at all stages. After all, 15 years later, it's time to get this in gear. So Bill C-77 does complete most of the rest of the reforms to the military justice system that were first proposed under Conservative government, but unfortunately left out when Bill C-15 was adopted in the last Parliament. I'm not quite sure why it took the Liberals 3 years to get this bill before us, because the Conservatives had introduced essentially the same bill in the dying days of the last Parliament. Now, for me, the most important part of those reforms that in Bill C-77 are those which add greater protections to victims in the military justice system. These were missing, they are missing, and these changes will align the military justice system with the Canadian Victims' Bill of Rights. So it is important not only that those who are accused are treated fairly, but those who have been victims of the offenses are also treated fairly in the military justice system. As I said, this bill implements most of the rest of the reforms first proposed under the Harper government and will modernize the military justice system, but there are still some areas in which it's lacking. We believe there are two areas in which improvements could be made without undue delay to this bill. One important provision in C-77 is found in Section 23C1. This section will allow military judges to take into account the circumstances of Aboriginal offenders when determining sentencing. This change is obviously welcome, as it's in keeping with the Supreme Court decision in the Gladue decision of 1999 with regard to how the criminal justice system operates in the civilian realm. However, we believe it's possible, given that this is 2018, nearly 20 years later, that we may be able to improve the wording of that section to allow greater clarification of its intentions and the impacts of this section. The second improvement we would like to see involves the subject of my questions earlier to the Minister and to the Conservative spokesperson. This is the omission of a reform that would help deal with the serious problem of suicide within the Canadian military. In October of 2016, the government announced a suicide prevention strategy, a strategy with 160 provisions to address the problem, which is very real in the Canadian Forces. We are still seeing 1 to 2 members of the Canadian Forces die by suicide each and every month. Think about that, each and every month. That's a total of more than 130 serving members who died by suicide from 2010 to the end of 2017. And when we're speaking just of serving members, obviously that excludes the very high rate of suicide among veterans, which the government was not even able to track when the report was issued in 2016. Today, we know at least 70 of those who served in the Afghanistan mission have died by suicide. Some of those are still in the military, and some of those having retired and become veterans. Self-harm is listed as an offense in Section 98 of the National Defense Act. 3 offenses are included in that Section 98. One, Section A, deals with malingering, and obviously, in a time of crisis, avoiding your duties should be subject to discipline. The second, aggravating disease or infirmity, I question whether that's really a necessary inclusion, although it seems a lot like malingering to me. It seems like it's repeating in B what it just said in A. It's the third section, Section C, that concerns me. And it says that anyone who willfully maims or injures himself or any other person who is a member of any of Her Majesty's forces or any forces cooperating therewith, whether at the instance of the person or not, with the intent thereby to render himself or that person unfit for service, or causes himself to be maimed or injured by any person, thereby rendering themselves unfit for service, is guilty of an offense. And the section goes on then, 98 as a whole, to set the possible penalties for self-harm as up to life imprisonment. Now, I ask you to think about somebody who's serving in the armed forces and suffering from mental health issues and needing help. Are you likely to go forward to your commanding officer and say, I'm about to commit a disciplinary offense? This is an obstacle to getting the treatment that those people need. It's a matter of human compassion. It's also a matter of getting the help so that Canadian Forces members who we've trained, invested in, and are part of a team can remain effective. So it's not only a moral question, it's also very much an efficiency question in the military. This is a major obstacle, as I said, to serving members seeking help, and omitting this section will have no impact on injury to other serving members. The minister's response to my question seemed to implicate that there was some problem in omitting this section, but I would assert, and we'll bring forward some witnesses at committee, that harm to other serving members is already covered in other sections of the Code of Conduct. So that removing this self-harm or asking someone to harm you or someone else really doesn't need to be there. And all those possible behaviors you could think of that the minister seemed concerned about are actually covered somewhere else. I want to speak for a moment about a tragic case that I know best, and that's of Corporal Stuart Langridge, whose family I have come to know well, as they reside in my riding. Corporal Langridge twice attempted suicide while he was a serving member. He failed the first 2 times, but he did not seek the help that he needed. And his family firmly believes that this section, which makes it an offense, was part of the reason that he didn't seek help. So this section, making a disciplinary offense, hindered rather than helped their son, and unfortunately, on his 3rd attempt, he succeeded and died by suicide. This led to an unfortunate attempt to cover up the details of his case, but that's not the topic here today. I do want to set that aside. The goal here is removing what I've heard from families, from veterans, and from serving members is a major obstacle to those who need help with serious mental health issues getting the help they need. Making self-harm an offense is clearly a relic of old thinking about the scourge of suicide, which continues to plague not only our military, but this entire country. One last major reform which was not dealt with in Bills C-16, C-15, and in this current bill, C-77, is that of the right to trial by jury. And we had, as has been noted earlier in the debate, a appeals court ruling last week, which ruled civil offenses are not offenses under military law if they're not connected to military duties. Now, that's an oversimplification of the case. In the case of Master Corporal Baudry, the government has appealed that decision. It was a split decision in the court, and has requested a stay of that decision until the Supreme Court can hear the case. The military justice head prosecutor Bruce McGregor has said that this potentially affects about half the caseload of the military justice system. So I'm not going to take a position today on what the proper decision in that case should be. That's the job of the Supreme Court, not politicians. But I think we can all recognize today that there may be further work needed if that decision is upheld by the courts. Experts like retired Judge Gilles Letourneau and the highly skilled lawyer from Montreal, Michel Drapeau, have argued that this is a question of fundamental rights and that it will not affect military discipline. But there have been concerns raised on the other side about the slowness of the civilian justice system and whether it can fully consider the context in which those crimes might occur. My biggest concern is that this ruling raises questions of the ultimate disposition of sexual assault cases, which were originally declared unfounded by the military police. The military police recently announced that 23 of those cases will be reopened for investigation. Why am I concerned about that? If this decision stands and those cases were transferred to the civilian system, they might fall under the time limits set in the 2016 Jordan decision, resulting in a dismissal because of unnecessary delays. So I think there's some very complicated implications that we have yet to see play out from this court decision. So let me say once again, the NDP believes C-77 should pass expeditiously, and we will support it. But in doing so, we should not neglect the opportunity to make some improvements. Most importantly, to remove self-harm as an offense in the Military Code of Conduct. Finally, let me restate the importance of these improvements to our military justice system. They are important to discipline, they are important to morale, and they are important as a right of those who serve. Members of the Canadian Forces are held to a high standard of discipline. Therefore, their judicial system should also reflect that high standard. Those that risk their lives for our country should not be denied their charter rights when facing trial. Other countries have recognized this issue and have changed their processes. It's time for Canada to catch up in this area. It's past time that we take the necessary steps toward ensuring that our military justice system ranks as a model system and a system which members of the Canadian Forces can be justifiably proud. Bill C-77 takes important steps forward, but there's still more work left to be done. Thank you, Mr. Speaker.
Thank you.